Today's tip comes from the amazing book, Recovering for Psychological Injuries by Bill Barton. If you haven't read this, please do. It goes way beyond just psychological injuries. And I'm not just saying that because Bill's here, but because it is really a tremendous book. And Bill Barton is here to read the tip.
Thank you, Michael, and good morning, one and all. Look for jurors whose life experiences permit them to equate substantial damages with a substantial verdict. Jurors who live on a fixed incomes or single parents who fight to make ends meet will believe that $10,000 is indeed big money. Tears are evidence that the jurors are going in the right direction, but a handkerchief's not proof that they'll go far enough. Now, I'd like to take that apart for a minute with you. There's a way to frame this that is in my book, and I'm not trying to shill that, but I call it you're shifting the measure of damages from a quantitative one or addition to a qualitative one. And that's very, very well illustrated by Mo Levine's story about who has lost more when you take away half from the beggar or half from the millionaire. Obviously, the millionaire's lost $500,000, but the beggar had so little. And that's, of course, found one more time in Luke 21, 1-4. I'm dealing with the parable of the widow. It's actually not a parable. It's a story of the widow and the mites. And it's a beautiful story. Now, here's where I'm going with this. And I'm going to give you a one-liner that nails this. When I pick a jury, particularly for people, say, that are on fixed incomes or live in a modest way, and I'm picking my words, I ask the jury panel, what is big to you and little to the world? Tell me about it. And then I become their scrivener, and I walk up to a blackboard and I just start writing down what they say. And when you're dealing with a widow on a fixed income, she doesn't have much. And here's what her answers are going to be. I really enjoy working in my garden. It isn't much, it isn't big, but I give it what I have. I can hear things like, I enjoy holding my grandchildren. That's big to me. It may not mean much. And I write these out on a blackboard so that I am honoring their truths. Now, that sets us up for the as-is instruction, the fin skull instruction, your uniform civil jury instruction, not the aggravation of a pre-existing condition, but the previous infirm condition. They're not the same thing. And I want to emphasize that. So I think there's a way to shift in an honest legal manner that's law-based from a pure quantitative, such as who's lost more, the beggar that's lost half or the millionaire that's lost half, so that it truly honors the fact when you have so little, it means a lot. And Mo Levine did a beautiful job of this, time again, with his stories of a person that perhaps only had 5 months to live and they were prematurely, their life was taken from them. What could have happened in the next 5 months or 150 days? He could have attended his granddaughter's high school graduation. He could have, and going down. So you've got to step back for a second and think about what it is and the way I think about this in my mind's eye, I create an axis. And one axis is vertical and the other one's horizontal. The vertical axis would be somebody's health, and 0 would be dead and 10 would be an Olympian, to overstate it. And across the top, I'd have a horizontal, which in A would be the pre-liability condition, B would be the liability event, and C would be the post-liability difference. So that if someone was a 6 walking down the street before and they were hit in the crosswalk and they became a 4, it would be 6 minus 4 for a difference of 2. That's caused by B, the liability event. Now, that's a very Aristotelian Cartesian way of thinking about logic. But when you really study what's available to you, now, I actually do some things that I give credit to Marvin Lewis and his first book Marvin passed away, but his book in 1983, Psychic Injuries, he really gave light to this model where you take the damages down on the scale of 0 to 10, because our instincts tell us we want them better before and worse after. That's because of the A minus C. Marvin would take him down to a 2 or a 1 and take him down to a half later and use the arguments of these qualitative losses as opposed to a quantitative loss. And here's what happens, and it's an unintended consequence. You're the most credible person in the room because you cannot exaggerate. Think about that right now. We spend half our career self-marginalizing by trying to expand the difference between A and C, before and after. Oh, you were great before, now it's terrible after. And then the other side just makes a living off of cross-examining our experts or our witnesses and make us look like we're exaggerating or gilding the lily. That's self-inflicted. There is a way to avoid that. And it's honest, it's moral, and it's legal. And I want to close with this. I don't mean to be disrespectful to anybody's religious persuasions, but I really enjoy that story of the widow and the mites. And in it, Christ had so little time left, and the Romans were dogging him everywhere he went. Any opportunity to accuse him of sedition or traitoring the Roman authority, they were welcoming. And so he had to speak in parables or stories. And he took this crew, the cock had not yet crowed, Peter not yet, and they were rather motley and unimpressive. And when they had a little time left, he came to this village in Luke 21, which is written by the physician, Luke. And they were sitting there, and there was this line of people coming by, giving their tithing and offerings to this god, the current popular god of the day. And people were just rich, and it was conspicuous, see and be seen time for giving. And the people's hearts really weren't in it so much as look at me and how humble and generous I am. And in this line, there was a widow, and she had 2 mites, M-I-T-E-S. And I actually have a couple mites in my drawer. You can buy these. And she put these mites out there, which are like pennies. They're about the size of the fingernail on your little finger. And when she was through, Christ turned and he said to them, "Who has given more?" And he gives them the answer. She has given more because she had so little. And there it is. It's positive law. It's in the instructions. You've got to ask for it and you've got to argue it. And if you think about where I started with this a few minutes ago, I talked about what's big to you and little to the world. There's your setup for closing argument right there. There's your case theme. And they don't dare come after and demean your client and argue how little she had, because you've already embraced it and turned it to your advantage. And I think this is done well by Keith Mitnick in his chapter 13, Owning Their Best Facts. It's about framing the case in a positive way. So I kind of gushed on you, and this is one of my favorite topics. And I just love that story of the widow and the mites, Luke 21, 1-4.
We love your gushing, and I'm going to share with you. It's also in the Torah or the Old Testament. There's a similar story. So interesting.
Really?
So
tell me about it, Michael.
I'm going to. I'm embarrassed that offhand I can't remember which book it's in.
Sure.
So I'm gonna add it to the comments.
Sure.
But I very well remember studying that chapter, and it had to do with the tax collection and who's given more.
Yes.
And it's the person who has the least. So it very much captures the theme you're talking about. And what's brilliant about it, amongst all your other brilliance, is you're right that the jury expects us to be the plaintiff's lawyer and come out and say that the relationship this parent had with their child was perfect, or their body was perfect.
No.
And when you come out and say this parent and child had a bad relationship, what? You get their attention, and they were hoping to heal it, and they took that chance away. Now you're the credible one. Thank you so much for that.
Well, I'd like to put one, I actually damn near get teary-eyed sometimes at the privilege of being a lawyer and representing people. And it took me a while to get knocked off my pedestal, I think. And instead of looking, I actually honor people in all their shortcomings and their frailties. And I represent real people that cry themselves to sleep, that have failed. And you don't need to run from that. You need to kind of embrace it, because there's an ethnicity, an ethos, an honesty about that. And what you're really doing, apart from being a decent human being, front and center, is you're being an effective advocate. Less can be more. It's counterintuitive. So just think about that. And thank you very much, Michael.
Today's tip comes from Bill Barton's book, Recovering for Psychological Injuries. Bill Barton is here with us today. Could you read your tip, please, Bill?
Sure, Michael. Thank you. And in no other area is the expert's testimony more important to the success of a case than in claims of psychological injury. Well, let's think about that. That's quite a Kantian statement, in no other area. I've thought about that, and let me tell you why I believe it's at least equal to an engineer in any kind of a mechanical case. I think that, frankly, these injuries, nobody can see them. They're emotional. The preferred treatment of choice is let's talk about it. And furthermore, the experts often, they have sorry, Michael, no disrespect, but their facial hair, and they think they're Sigmund Freud lookalikes or something. And they have this arcane Byzantine language, which is so obtuse that nobody can understand them when they get into the psychiatric nomenclature. And so this is really a problem. And you're supposed to convince people that an injury they can't see is big and they're supposed to give a lot of money for it? Really? Well, let's talk about how you go about that. I'm going to give you a couple of simple techniques. I think that the first thing you need to do is think about going to your Bible, a DSM-5, Diagnostic and Statistical Manual 5. It came out in 2013, and I think in another year or two we'll be getting DSM-6. And I take, let's use post-traumatic stress disorder, 309.81, and I actually take the diagnostic criteria from the book, and I enlarge it and have the expert step up and say, Doctor, would you take us to school for a moment, respectfully? Would you show us the criteria that you've applied through the book? And is this a book of medicine? It is. DSM-5 is a book of medicine dealing with the area of psychiatry and psychology. Number two, would you go down each one of the criteria and read it for us and then explain to us what facts you relied upon? And remember, I think it's under 803 sub 4. It's always an exception to the hearsay rule, anything an expert relies upon pursuant to forming their diagnosis or treatment. So in it all comes. It's an exception to the hearsay rule. They relied upon it. And they go down each separate criteria. And then when they're through and they explain the facts in support of that, I have them check it off. And then I offer as demonstrative evidence to help illustrate the oral testimony of the witness, the diagnostic criteria, and in it comes. And it goes back to the jury room and it keeps on testifying for you. So I think that's kind of a nice talisman or model to use. It's been very effective for me. What I'd like you to think about now is I'm going to talk, just to go a little off record, but there's a paper I'm going to post on my website probably in about 2 weeks. And it deals with recovering for psychological injuries, and it gives you a good working model of the new DSM-5 PTSD. And why am I saying that? Because believe it or not, before 1980, PTSD didn't exist. It wasn't in DSM-1 or DSM-2. It wasn't until the Vietnam conflict and the returning veterans faced the horrors of war, and it became part of our cultural dialogue. Then, frankly, with the women's movement and matters of sexual exploitation, and look at today, the idea of public violence and shooting and children in schools, it's very much a part of our public dialogue. But that wasn't always true. When I first started doing these cases in the early 70s, there was no PTSD. Can you believe that? It didn't exist. It wasn't a page in a book. I found that very interesting at the time. And finally, the literature started catching up with the reality that we've all lived. And there it is. So I take this pretty seriously, and I think you need to work with your experts very carefully to make sure that they drop all the big words. They don't need them. Just go right down the diagnostic criteria, read them, and then what facts. And then also what I want to add is anticipate any causation questions. Because when you have somebody that's emotionally injured, one of the great defenses is to point out how they were a basket case ahead of time. And of course, between two friends, that's the as-is instruction, previous and firm condition, that you own their best facts. So don't minimize that at all. And it's appropriately addressed by the law. And the new DSM-5 talks about predisposition very explicitly. So I I'm going to have that paper on my website. It's worthy of you referencing. It's there for your public access. And this is not a matter of just standing up and mumble jumbo.
We'll get the link to that if you'll send that, Bill, and we'll put it in in this post. Thank you for being very specific in what you're suggesting we do. It's very wise. I've learned recently, I can't remember who taught it to me, that you're right. The public had never heard of PTSD, and now I understand there's actually the military uses certain diagnostic tools. It's beyond DSM, but definitions of PTSD for the military. So it's very interesting.
Fact, when you study the literature, first responders in military are trained in advance. That's what they do. They deal with conflict and drama. And they are actually, it's interesting, those people rarely have an immediate symptom. It's usually delayed. And DSM, the PTSD is one of the few that it does not require an immediate emotional response because there may be a numbing, an intentional avoidance. And for first responders in military, they will ignore it.
Yeah.
But it doesn't mean it doesn't have its impact. It's just delayed.
That hits home. I'm sorry, that hits home for me. My brother's a helicopter pilot for Life Flight. So seeing this stuff and hearing him talk. So this is very helpful this morning. Today's tip comes from the book Recovering for Psychological Injuries by Bill Barton. Here to read it is Bill Barton.
Thank you, Michael. Good morning. Long before you ever enter the courtroom, plan a minimum of 2 pretrial sessions of at least 1 hour each to prepare an expert for trial. I think one sometimes gets a little bit comfortable in your own skin after 500 jury trials, and I think I know how to do this, and I forget that the expert may never have been in the courtroom before. And I make it a point of honor to bring in treating therapists, and often they have master's degrees only. They're not terribly well credentialed like a psychiatrist or a PhD psychologist or PSYD. And I forget sometimes how traumatic it can be for them. So there is something to be said for me going out of my way to be, if you're going to be an effective advocate, you're no better than your witnesses and your responsibility. That's your job. And I forget that sometimes because I think I'm dealing with a professional that's competent. And sometimes it does slip even for me after 500 jury trials that I need to go out there and start fresh with each one.
Bill, now, how do you deal with it when your expert says, I've done this many times before, don't worry, I don't need prep, I know what I'm doing?
Well, I'll tell you, I don't hear that too often, but let's assume that I did. I would say, fine, why don't you give me a 10-minute preview of what you're doing? And here's some of the things you're going to see right now. And I actually, there's a very seductive way to invite them to become a teacher instead of a lecturer. And that is, I use words, listen to my nosology or my jargon. Would you please share with the jury, doctor? Take us to school, respectfully. And are there any big words we should be talking about before we get started you can't avoid? And it seems to me like doctors like talking about big words sometimes. And by doing that, it kind of empowers them in a strange way. And once we get that out of the way, then they can talk more normally because I've given them their ode or given them so there's a lot of ways to deal with that kind of excessive confidence. And I'm not saying that they're not great. You should be, but they probably aren't. And I don't think most experts can grade their own paper, frankly. I don't believe that. I don't believe that at all. They're used to talking to people that are at least college educated, if they're professors or teachers or otherwise, and they're just not used to communicating at an 8th grade level. And that's not disrespectful. I have the same problem myself. I mean, I began into my jargon, my nosology, listen to my language. I'm talking like a damn lawyer. And it's important that, and I'm being self-critical here in front of you, but I came from a lower socioeconomic blue-collar background, and frankly, I kind of escaped, and I think in ways I was born into Les Miserables, into the sewer, and I escaped because of my ambition and drive and insecurities and became bilingual, and I got a law degree. So I get to go into this courthouse and talk to people, neighbors. And I have to remind myself that I'm talking to real people. And I have to drop this legal jargon and be bilingual. When I'm talking to the court, of course I need the King's English, the words of art. But when I'm talking to people to cry themselves to sleep and listen to country and Western music, they don't need my nonsense. Talk to them, be bilingual. And I think that's the same rule that applies to an expert. And it's not easy because we ourselves often break these very rules, particularly when you're going from the court to the jury, and you're dealing with an abstract legal concept, res judicata. I mean, really, what does that mean for neighbors? And here we go, a contract to the court and keeping your word for neighbors.
Yeah,
So
bilingual, this translating, a pet peeve of mine, and people who even go out of their way to try to translate, because you're right, translating the language of law to the language of the everyday. One of the things that bothers me, I'm curious your thoughts on this, I think a lot of people disagree with me, is, and then we start and say, okay, now we're in voir dire, and we speak Latin. I like to say jury selection. Now we're going to select our jury. But there's a lot of things like that where we just take it for granted.
I think so. And I think I'm guilty of that. And sometimes, as I get older and I get older and older, I become further removed from Gen X, Y, and Z. And they're very techno and I am not. So it isn't just our choice of words. It's how we communicate. And I'm still kind of a flip chart guy, but fortunately I have my 43-year-old son as a law partner that kicks me in the knees once in a while and says, hey, Dad, hello, have you grow up? And so we're all freshmen if you're properly rigged to continue to grow, because we are yesterday's news and these young people grade our paper. Think about that. I'm 75 next month and I'm having an 18-year-old juror grade my paper. Yeah, it's true. And it's very healthy for me. Thank you.
Bill, will you read to us your tip from your video direct examination, please?
Yeah, I think I want to tell you, while it's specific to direct examination, it's gestalt and applies to the entire process of being a jury trial advocate. And it reads, trials are about the generation, acquisition, consolidation, and then the utilization of the intangible attribute of credibility. If you don't have credibility, a jury won't care what you say. Now, let's just break this into parts. It's my view that jury trials are, in part, referendums of citizenship, of you and your client. Number two, I believe that when you're standing on your feet in closing argument, and in particular when you're urging psychological injuries, significant dollars, an injury no one can see, I've got to have credibility. Because in effect, I am the most important unsworn witness the jury sees. Now that's something to think about right there. I'm an unsworn witness. And I'm the director, I'm the producer, I bankroll the operation. I'm a script writer in the sense that I help the witnesses with their testimony, and then I'm actually co-authoring its delivery. So for us to sanitize ourselves out of this process as if we're simply some transactional object misses the reality of what we are and what we do and what we should be. So I take this seriously and think about it's my job. I'm a plaintiff's lawyer. I start the trial and I do not presume an ounce of credibility. I have to earn it. Think about that. I have to earn it and I have to generate it. That's earning it. That's a verb. And then as I'm generating it, I need to be acquiring it, personifying it, my ethos, consolidating it. And then at the time of closing argument, I'm going to utilize it. I'm going to be specific. I'm going to stand up and I'm going to ask for a very significant sum of money for an injury no one can see. Now that's not easy to do. And I think you must think about your own credibility and everything leading up to that time when you stand on your feet in closing. And I think of this as a verb, as an action process, and it's a dynamic one. And I hold myself to the highest standards. I want to step aside for 1 second. One of the things that I think that's lost is the importance of, and I'm going to say this two different ways. I think that as plaintiffs' lawyers, we need to wear not just the white hat, but the whitest hat. Now think about it, because we're the only ones that face the burden of proof. We're the ones that tort reform's all about. We've got a target on our back. And I think we need to accept the responsibility that we need to earn credibility. Now, that could be daunting, but it is important. And think about it again. You know it when you see it. It's like, obscenity. If you don't have it, I'll tell you what, you don't care what somebody says. So it deals with your ethos, your personhood, your character, how you treat everybody, how you treat the court staff, how you treat your witness, and how you treat your opponents. And I want to make one other comment on that point. I call it weaponizing professionalism. And I did that intentionally because it's catchy. And it gives a spin to professionalism that I think honors the reality that it is important as a tool or resource. So while direct examination is about generating credibility, the whole trial is about generating credibility. And I refuse to participate in anything, including a mud fight with a pig. I will not do it. It's going to jeopardize my credibility. And in fact, the worse I get, the better I get. And I welcome the contrast so that, and by the way, people read my book and they all come in and you think they're Sonny, Jim, and Jane off a jam jar. You know what I mean? Everybody's just just so sweet. Well, I kind of miss the days when I had people opposite me. Don Keenan calls them the black hats. Because the people that are opposite me now are really elite, high quality performers of the best character. And if there's something less than that, that's to my advantage, and they don't show up at this level. So I think it's a whitest hat, and you need to accept that seriously. And then, something, the last thing I'm going to say, if you happen to lose, believe it or not, it will not be because you co-authored it. Maybe your facts weren't good, because you did everything right and stayed the high ground, and you believed in the system, you honored it, you brought the best of, I call it my better angels, to quote Lincoln's first inaugural address. And so I'm very serious about this whole generation, acquisition, consolidation, and then the utilization of credibility. And because when you do psychological injury claims, you've got to have it, or you ain't going nowhere.
I love
Thank
it,
you, Michael.
Yeah, no, it's about credibility. I would maybe suggest a reframe that we could talk about good hats
Sure.
and bad hats without attributing colors to them in our.
Thank you, Michael. I just quoted Don Keenan. That was a poor choice.
No problem. Today's tip comes from the video Concepts in Jury Psychology by Bill Barton. Here to read it is Bill Barton.
Thank you, Michael, and good morning. And let me begin with the reading and then a bit of an explanation. Consistent evidence strengthens a trial story, while inconsistent evidence is often ignored. What's going on subtextually underneath this? Well, it's called a confirmation bias. Now, before I develop that, which means I told you so. And now let's back up for a second. I want to give you a theoretical set of predicates. I believe there are three stories in every trial. There's your story, the other side's story, and the jury's. The trick is to tell the jury's story in your client's voice. How do you do that? That's what focus groups are about. And I don't want to knock you off your pedestal, but we suffer the advantage of 4 years of college, 3 years of law school, and we are disqualified from thinking like average people. We praise linear, deductive, sequential, pedantic, rote, mechanical, analytic thinking. That's got nothing to do with how people think intuitively. They form opinions and conclusions, and then they later rationalize it. That's why I told you so. It's kind of a just world hypothesis within what the social psychologists call, and it allows people to organize the world in a way that makes sense for them. So your job is to find out what the jury story is. Eric Oliver talks about this in Facts Can't Prove Themselves. There's many good minds that have spoken this, but it's kind of common sense. But the application requires you to get outside of yourself with an ounce of modesty and go out, and it can be very informal and de facto focus groups, and give them part of the story and ask them, what do they think? And they'll tell you what they think the rest of the story is about. It's very interesting, as opposed to the deductive kind of a focus group where you talk from the top down and then they react. You give them part of the story, some of the heart of it, and then ask them to fill in the blanks. And in the very process of doing that, they're telling you what they think common sense looks like. Then, once I've done that work, I try and sit back and look at my inventory of facts, particularly with the plaintiff, and I try to find the places that match up or overlap in a Venn diagram between what my client's thesis or story is and how well does it match up with the jury's story. And those are the areas of emphasis. So that's what I mean when I say consistent evidence strengthens a trial story. The key is to tell the jury story in your client's voice.
I love this. And it really requires us as the lawyers to get out of our own way. I've got a trial, I've been working on doing focus groups, and there's something that I think is so logical, and I keep presenting it to focus groups, and they keep telling me that they don't care. So I've had to back down and say, okay, what do they care about? Maybe it's not logical to me, but I need to embrace that.
I find it rather healthy and painful concurrently for me to be subjected to the judgment of an 18-year-old juror when I've lived and practiced 75 now, going on next month, 51 years of practicing law, and this kid's telling me what's right and wrong. And the reality is they are empowered, not me. And that can be very emasculating, humbling. It can invite a certain negative reaction, like, who in the hell are you? Well, I'll tell you who they are. It is local government at its best. Now, you think about that for a second. That's a framing thing for a jury, the process. It is government. It's structurally embedded within our Constitution. And it is local government in its most primitive, visceral sense. And to suggest what it's not says more about you than their reality.
What you're suggesting is really a deference and a respect for the jury, that you have to have that to be a successful lawyer.
That's Mo Levine through and through, the conscience of the community. That's rules of the road, spreading the tentacles of danger, safety, giving us all something that we can invest and buy in. So this jury verdict isn't just about money trading hands, but it's about community-based notions of fair play and justice. And if you're not heading in that direction, you're going the wrong direction, my friend.
It comes from Bill Barton's video, Direct Examination. And here to read it for us is Bill Barton himself. Good morning, Bill.
Hey, good morning, Michael. Nice to see you again. Let me begin with direct examination isn't sexy. Few lawyers pay attention to it because we aren't scared about looking bad in direct. But it's the one area of a case as a plaintiff's lawyer in which we must succeed. Let me play with that for a second. This is not very flattering, but I used to pay a lot of attention. I started out on the criminal defense side. And sometimes, like when you get into federal court, the federal judge will do the jury selection virtually for you. And I wouldn't put my client on the stand. So about all you really had was your cross and your closing. Because I wasn't calling my client in a case in chief, there wasn't a lot of direct examination. So when I was being raised on the criminal side and I enjoyed success early, I never really honed my skills on direct examination and did not appreciate its importance until I moved over to the plaintiff side. Then the second truth that kind of hit me between the eyes, and this is me being rather self-deprecating to you, I thought I was pretty good at cross, and I didn't give the attention direct needed. I couldn't figure out why, because I'm not dumb. And I'd read people telling me how, and I realized that it was about me. And here was my private truth. If it goes poorly on direct, the witness looks bad. If it goes poorly on cross, I look bad. And that wasn't a very flattering insight for me to come up with. It was really about me and my fear of looking bad or my desire to look good. And as a result of that, I completely didn't invest the time I needed as an aspiring plaintiff's lawyer in direct examination. Because if you don't have a good winning case at the end of your plaintiff's case when you rest, you're not going to be able to make up for it in cross. It's not going to happen.
Wow.
So pardon me, Mike.
No, as you say, there's just so much wisdom in there. The first being it's not about you, and the second being that the cross-examination is this, like, we're waiting for the magic movie moment, but direct. The more I practice and the more trials I have, the more I enjoy direct. We get to shape direct. We get to tell the story exactly the way we want.
I thank you, Michael. I tell you what, that was a rather embarrassing insight I just shared with you, and I don't ask you to, but it's worthy of you reflecting. The next time when you're preparing on your trial and you're spending so much time on cross and you're investing, back up and take some of that time and move it over to direct, because that's where it's at as a plaintiff's lawyer. And there's a lot that it takes. And when direct is done well, it looks like a natural conversation, almost like two people just playing catch, like Forrest Gump with a box of chocolates at the bus stop. And yet it is so difficult. You can't suggest the answer. You can't look like you're playing to sympathy. And it is so difficult when it's done well. And when it's done well, it looks so easy. It's the ultimate contradiction. It's like watching a professional athlete do something that is so difficult and they make it look easy. There were thousands of hours they put in preparing to do that, to make it look easy, and it is not. So I think this direct examination of the 5 different inventories of skills breaking into trial: jury selection, opening, direct, cross, and closing. It's my observation that when you put on seminars, the big ones people are willing to attend are closing, jury selection because it scares them, and cross. Nobody wants to go to a seminar on direct examination. Nobody wants to go to a seminar on opening statement. And they're 2 of the most under-harvested areas as plaintiff's lawyers. We get to frame what it's about. We get to go first. We have primacy. And so I want you to know took me about 20 years in my judgment. I've been doing this now for 51 years and 500 jury trials. I believe it took me about 20 years to become pretty good at direct. And I was ahead of that in cross, which I shined at early. I was comfortable in jury selection, and I did not appreciate the power of opening statement and direct examination.
Today's tip comes from Bill Barton's Recovering for Psychological Injuries. And here to read the tip is Bill Barton himself. Good morning, Bill.
Hey, good morning, Michael. Well, let's begin. Shall we listen carefully to the questions of opposing counsel? Preempt the defense by asking them yourself. This leaves little for the defense to discuss with the jury, reducing the opportunities for them to build rapport. It also confirms you're only interested in a fair trial. Now, the way you kind of sense this was you can tell from the depositions what their 2 or 3 long suits are, what they want to go to. And you've framed this. And I think I want to go out of my way to give a shout out to Keith Mitnick and his book, Don't Eat the Bruises. And his chapter 13 does a beautiful job in that, of basically talking about owning the other side's best facts. And preemption is a powerful thing where you self-accredit. Now, I'm not asking you to re-script the facts, but in my mind, jury trials, and I'll mention this later, are about the generation, acquisition, consolidation, and utilization of the intangible attribute of credibility. And let me prove it to you for a second. If you don't have credibility, it doesn't matter what you say. I can tell you the sky's blue and nobody cares. So think about this whole thing as you being, in my mind, the most important unsworn juror that the unsworn witness that the jurors will hear. So that's kind of an interesting framing of who you are and your presentation that's very large. And so this is a thin slice of a larger construct that I try to use, which is about the accrual of credibility and about preempting. And respectfully, I think well of all my opponents. I never sell anybody short, and they have a story to tell. And I'd like to weld their story within mine so that I'm basically doing the beginning, the middle, and an end. And now I'll develop that further, but that's the guts to it. And it's important.
So what I hear you saying is that by, I would call it embracing the defense or owning your the negative parts of your case. Not only are you framing it the way you want because you take it on first, but more importantly, it's part of the credibility that you are from an honest place, not afraid of the truth. You're the one presenting
Michael,
all of the truth.
You said it beautifully. I don't know that I could do any better than to repeat that. But if you think about this as a verb, a trial as a verb, and you as an object, and you're in control of a lot of things, including yourself, and it's your job to invest in yourself at all times and places. Assume a jury's watching you in the parking lot, in the elevators, and in a sense, jury trials are referendums of citizenship, and you lead.
I love it. Thank you so much, Bill, for being here this morning, for sharing your wisdom with us.
Thank you, Michael. The best to you, my good friend, and all of you out there.